A Supreme Court justice just publicly insulted a congresswoman, on live record. But her response? Calm, calculated, and unstoppable. In the next few minutes, you'll witness a confrontation that shocked Washington, captivated the nation, and exposed how fragile even the highest authority can be when challenged with facts. Stay with us, this is the moment judicial power met accountability like never before. The Supreme Court chamber fell silent as Justice Neil Gorsuch leaned forward, his expression stern and dismissive. The annual congressional oversight hearing on judicial transparency had been contentious from the start, but no one expected what happened next. Congresswoman Crockett, Justice Gorsuch said, his voice carrying clearly through the ornate chamber. Your fundamental misunderstanding of constitutional separation of powers is precisely why some legislators should go back to law school before attempting to question this court's internal procedures. The chamber froze. Several senators exchanged shocked glances. Never in recent history had a Supreme Court justice so directly insulted a member of Congress during formal proceedings. The committee chairman half rose from his seat, clearly uncertain how to address this breach of protocol. Congresswoman Jasmine Crockett remained perfectly still for 3 measured seconds, her expression revealing nothing. Then she opened a leather portfolio with deliberate calm and removed a single document. Justice Gorsuch, she began, her voice steady and clear. I appreciate your concern about my legal education. Since you've raised it, perhaps you'd be interested in reviewing the amicus brief I authored in Carpenter v. United States, the one your majority opinion cited favorably on page 17. She placed the document on the table before her. As for constitutional separation of powers, I'm simply inquiring about the implementation of existing ethics standards this court itself acknowledged as appropriate in its own 2019 statement on judicial conduct. I'm not proposing congressional interference with judicial independence. As my actual question made clear. The gallery erupted in murmurs. A veteran Supreme Court reporter would later describe witnessing the rarest of Washington phenomena, a moment of genuine intellectual accountability. What happened in the next few minutes would not only captivate the nation, but fundamentally alter the relationship between Congress and the Supreme Court for years to come. Before diving into this extraordinary confrontation, comment where you're watching from and don't forget to subscribe so you won't miss our analysis of the most consequential moments in American governance. To understand the full significance of this confrontation, we must examine who these two legal minds are and the context that brought them into this unprecedented clash. Justice Neil Gorsuch had followed a path of consistent conservative jurisprudence throughout his career. After graduating from Harvard Law School and earning a doctorate in legal philosophy from Oxford, he had served on the 10th Circuit Court of Appeals before his appointment to the Supreme Court in 2017. Known for his originalist approach to constitutional interpretation, Gorsuch had established himself as an intellectual force on the court, writing opinions that often emphasized textual analysis and historical understanding. Those who had appeared before him in court consistently described Gorsuch as demanding but fair, a jurist who expected thorough preparation and precision from attorneys. His questioning during oral arguments was typically incisive rather than confrontational, focusing on testing legal reasoning rather than attacking advocates personally. This made his uncharacteristically dismissive comment to Congresswoman Crockett all the more surprising to court observers. As one legal analyst later noted, this wasn't the careful measured Justice Gorsuch we've come to expect. Something about this particular hearing clearly touched a nerve. Congresswoman Jasmine Crockett brought an equally substantive legal background to her role in Congress. Before entering politics, she had built a distinguished career as a civil rights attorney, handling complex constitutional cases and developing particular expertise in judicial ethics and accountability. A graduate of the University of Houston Law Center, where she had served as an editor of the Law Review, Crockett had later taught courses on constitutional litigation at her alma mater. Her election to Congress had been preceded by service in the state legislature, where she had earned respect from colleagues across the political spectrum for her precise legal analysis and focus on substantive policy outcomes rather than partisan positioning. In Congress, she had secured a seat on the Judiciary Committee where she typically approached oversight hearings with meticulous preparation and specific focused questioning. Representative Crockett doesn't ask questions she doesn't already know the answers to, observed a senior committee staff member. It's like watching a skilled trial attorney in action. Every inquiry has a purpose, and she's usually 3 steps ahead in her thinking. The hearing that brought these two legal minds into conflict focused on judicial ethics and transparency standards, a topic of increasing public interest following several high-profile controversies involving judicial conflicts of interest. Congress had been considering legislation to formalize ethics requirements for the Supreme Court, similar to those already applicable to lower federal courts. The Supreme Court had preemptively responded by announcing its own internal statement on ethics principles and practices, a non-binding document that outlined the justices' commitment to ethical conduct, but stopped short of establishing enforceable rules or disclosure requirements. This self-regulatory approach had drawn criticism from transparency advocates who questioned whether internal guidelines without external accountability were sufficient. The Supreme Court oversight hearing had begun like many others in Washington with formal opening statements, procedural courtesies, and the carefully measured exchanges typical of high-level governmental proceedings. The ornate hearing room with its rich wood paneling and imposing portraits of former Judiciary chairmen added to the sense of institutional gravity. Justice Gorsuch along with Justices Kagan and Jackson had presented a united front despite their different jurist philosophies. All 3 emphasized the court's commitment to ethical conduct while maintaining that formal external regulations might compromise judicial independence. The court takes its ethical obligations with the utmost seriousness, Gorsuch had stated in his opening remarks. The principles we've articulated reflect centuries of judicial tradition and practice. We believe they appropriately balance transparency with the constitutional necessity of an independent judiciary. The exchanges with committee members had followed predictable partisan patterns. Republican members generally expressed support for the court's self-regulatory approach while Democratic members pressed for more specific accountability mechanisms. The exchanges, while occasionally pointed, had remained within the bounds of typical congressional decorum. When Congresswoman Crockett's turn arrived, she began with what appeared to be a technical rather than ideological line of questioning, focusing on practical implementation rather than abstract principles. Justice Gorsuch, I'd like to understand the practical application of the court's statement on ethics principles when a potential conflict of interest arises. What specific process exists for justices to receive guidance on recusal decisions? Gorsuch's initial response emphasizing individual judicial determination rather than institutional processes prompted Crockett to press for greater specificity. If a justice is uncertain about whether a specific situation creates an appearance of impropriety, is there a formal mechanism for obtaining guidance? Lower courts have ethics committees and formal advisory processes. Does the Supreme Court have anything comparable? This focus on specific institutional processes rather than general principles appeared to irritate Gorsuch, whose response carried a noticeably defensive edge. Congresswoman, the Supreme Court is constitutionally distinct from lower federal courts. The Chief Justice has addressed this matter repeatedly. We consult appropriate sources of guidance including judicial ethics, opinions, and historical practice. Rather than being deterred, Crockett maintained her focus on specific processes, adding a comparative dimension. I understand the constitutional distinction. Justice Gorsuch, I'm specifically interested in the practical implementation. For instance, the International Court of Justice has a formal advisory process for potential recusals while maintaining judicial independence. Has the Supreme Court considered any similar structured approach? This reference to international judicial practices appeared to particularly provoke Gorsuch, whose expression darkened visibly. Congresswoman, American constitutional law is not determined by reference to international tribunals. Our system of government has its own traditions and structures that have served us well for over 2 centuries. Crockett then shifted to a more direct line of questioning about specific cases that had raised ethical concerns. Justice Gorsuch, when Justice Thomas participated in cases involving the 2020 election while his wife was actively involved in efforts to overturn the election results, what specific process was used to evaluate that potential conflict? I'm not asking for the substance of any deliberations, only whether a formal evaluation process existed. His face flushed slightly as he delivered the comment that would soon reverberate across legal and political circles. Congresswoman Crockett, your fundamental misunderstanding of constitutional separation of powers is precisely why some legislators should go back to law school before attempting to question this court's internal procedures. Several committee members straightened in their seats, clearly surprised by this departure from judicial temperament. Justice Kagan, seated beside Gorsuch, glanced at him with barely concealed concern. Crockett demonstrated preparation and composure that would later be analyzed in law schools nationwide. Without displaying anger or defensiveness, she removed the document from her portfolio, a copy of Gorsuch's own majority opinion in Carpenter v. United States with relevant sections highlighted. Justice Gorsuch, I appreciate your concern about my legal education. Since you've raised it, perhaps you'd be interested in reviewing the amicus brief I authored in Carpenter v. United States, the one your majority opinion cited favorably on page 17. As murmurs spread through the gallery, she continued with the same measured tone. As for constitutional separation of powers, I'm simply inquiring about the implementation of existing ethics standards. This court itself acknowledged as appropriate in its own 2019 statement on judicial conduct. I'm not proposing congressional interference with judicial independence, as my actual question made clear. Rather than allowing the exchange to devolve into personal confrontation, Crockett immediately returned to substantive questioning. To clarify my inquiry, the court's own statement acknowledges that the justices consult with colleagues in certain instances. I'm simply asking whether there is a formal process for such consultation on ethics matters similar to what exists in other high courts globally and in our own federal judiciary. This question is entirely compatible with judicial independence and separation of powers. Crockett's pivot from defending her credentials to restating her substantive question with even greater precision created a dramatic contrast with Gorsuch's emotional response. The justice found himself in the unusual position of having to acknowledge both his citation of her legal work and the legitimacy of her clarified question. I apologize for my intemperate remark, Gorsuch finally said, his judicial composure somewhat restored. To answer your specific question, while there is no formal ethics committee, justices do consult with the Chief Justice and colleagues on recusal questions, though the ultimate decision remains with the individual justice. This substantive response represented a significant moment in the court's transparency about its internal operations. Crockett acknowledged the response with a professional nod. Thank you, Justice Gorsuch. That clarification is helpful for understanding the court's approach. Rather than pressing her advantage after Gorsuch's apology, she proceeded to ask similarly specific process-focused questions of Justice Kagan and Justice Jackson, creating a comprehensive record of how ethical considerations were handled within the court. This methodical continuation, neither gloating over Gorsuch's retreat nor abandoning her substantive inquiry, demonstrated that her goal had been institutional accountability rather than personal confrontation all along. As the hearing continued, the impact of the confrontation between Justice Gorsuch and Congresswoman Crockett began reverberating well beyond the committee room. Clips of the exchange were already spreading across social media with particular focus on the moment when Crockett calmly referenced Gorsuch's citation of her own legal work after his dismissive comment. Inside the hearing room, a subtle but significant shift in dynamics had occurred. Justice Gorsuch, typically confident and assertive in his questioning, now responded with noticeably more measured and specific answers to subsequent committee members. Justice Kagan, perhaps sensing an opportunity to demonstrate the court's commitment to transparency, provided unusually detailed responses about internal ethics consultation processes. The committee chairman, recognizing the historical significance of what was unfolding, extended the hearing to allow more comprehensive questioning. This additional time revealed a pattern. When questions focused on specific processes rather than abstract principles, the justices provided substantially more informative responses about the court's internal operations. Outside the hearing room, the confrontation was generating extraordinary attention across legal and political circles. The video had been viewed over 10 million times within the first hour, with law professors, judges, and legal analysts providing immediate commentary on its significance. What made the reaction particularly notable was how it transcended typical partisan divides. While Democratic commentators naturally celebrated Crockett's effective questioning, Many conservative legal scholars also acknowledged the substantive nature of her inquiry and the inappropriateness of Gorsuch's dismissive response. A prominent conservative federal judge tweeted, "Questioning a member of Congress's legal credentials rather than addressing their substantive inquiry is inconsistent with judicial temperament." Regardless of political affiliation, Justice Gorsuch's apology was appropriate and necessary. Law school faculty nationwide began incorporating the exchange into their teaching materials almost immediately. A professor at Yale Law School noted, "This exchange perfectly illustrates both the proper function of congressional oversight and the importance of preparation in legal advocacy." Representative Crockett demonstrated the pinnacle of professionalism by responding to a personal attack with substantive evidence and a refocused question. By mid-afternoon, the confrontation had attracted international attention with legal publications from the United Kingdom to Japan featuring analysis of its implications for judicial accountability. The Financial Times ran a feature titled, "When Judicial Independence Meets Democratic Oversight," using the exchange as a case study in the delicate balance between these constitutional principles. What particularly captured attention in legal circles was the revelation about Crockett's amicus brief in Carpenter. Court watchers immediately located the reference on page 17 of Gorsuch's majority opinion where he had indeed cited her analysis of historical Fourth Amendment protections approvingly. This concrete evidence of her legal expertise made Gorsuch's dismissive comment appear not just intemperate but factually unfounded. As this background emerged, public perception increasingly focused on the substance of Crockett's questioning rather than the momentary drama of Gorsuch's insult. Her inquiry about specific ethics consultation processes marked a turning point in how the Supreme Court's internal operations would be scrutinized publicly and academically for years to come.